Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Now, let's get to the docket today because we've got a great one. First, I think we have a hero developing in the Laundrie Vallow and Chad Daybell matters. A hero for freedom, that is. We have an update on Harmony Montgomery. The cops in the Breonna Taylor case, remember that case? A couple years old now? Well, now they have some federal problems. Gabby Petitio's mom says that Brian Laundrie lied to make himself look better. Duh. Another real-life story which is crazier than fiction. And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk. My name is Scott Reich. You know the drill. Subscribe if you haven't, like if you do, hit that bell for notifications. And remember, you can listen to us all the time, anytime, by simply downloading us on any of your favorite podcasting apps, which includes Spotify, Audible, Apple. You know, if you listen to it, you can find us there. Crime Talk with Scott Reich. Okay, well, let's go ahead and open the record for Thursday, August 4th of 2022. The first story we have today is a hero that is developing, okay? And how did we find out about this hero? Well, we monitor what takes place in the Laundrie Vallow Chad Daybell matters. Well, interestingly enough, there was an order that came out and said that there's going to be a hearing on August 16th at 9 a.m. before Judge Boyce in the Chad Daybell matter. So the question then becomes, is this a hearing regarding the motion for consumptive testing that had been filed previously by the prosecution? Or could it be a motion filed by an attorney who is now a writer and a member of the media? That's right. So let's take a look at these motions, okay? There's a motion to intervene by a woman by the name of Lori A.G. Hellis. And she basically says she wants to intervene in the case, basically says, I have reason to be involved in these court proceedings. And she is basically challenging the court's decision to close hearings and seal documents and in general, limit media access to court records and proceedings in this matter. This is great. And this is her motion to intervene. And she cites Idaho Rules of Criminal Procedure 24 and Idaho Court of Appellate Rules 32. She's also filed a declaration of intervener and intervener memorandum of facts and applicable law. This is great. I just wish, I guess I was considered a true member of the media. I don't know. Do I get like media credentials somewhere? You know, we should, maybe we could intervene with her. The other motion that was filed by Miss Lori A.G. Hellis in both the Laundrie Vallow and Chad Daybell matters is a motion to unseal all documents and transcripts or recordings of past hearings. Hear. This is good. And she wants the court to review all of the sealed records and recordings of hearings and properly redact all statutorily protected information before unsealing those documents and recording into the court records. That's fair. There are certain things that are private, and we'll get to that. And then here's her declaration. I love this. Declaration in support of motion to intervene and the motion to unseal and a motion for injunctive relief. Ms. Hellis states that she is a retired attorney licensed in both Oregon and Arizona. She is inactive in both jurisdictions, but in good standing because basically she's retired. She's a published author and holds valid press credentials with International Federation of Journalists. In addition, she is presently under contract with Pegasus Books to write a book about the Daybell case, and therefore she's a member of the media. And in this consolidated matter, the court frequently has and consistently limited the public and the media's right to access hearings and documents without a prior hearing or sufficient justification. She cites Idaho Appellate Rule 31 and the Idaho Constitution, a United States Constitution that requires that the public and the media be permitted access to court records and proceedings subject to certain limitations. The rules further require that the court hold a hearing after notifying all interested parties before sealing documents or closed proceedings, and Idaho law recognizes the legal standard of members of the media to intervene in court matters for the limited purpose of challenging the media's right to access court documents. Good for her. This is getting good. And then her memorandum in support of the motion to intervene. And it basically starts off that she has standing as a member of the press and that she is petitioning to do this. And like good legal writing, she starts out with facts, okay? Facts. This matter came before the court when defendants Chad and Laundrie Daybell were charged, and they list all the case numbers. The sealing of court documents began almost immediately. The following entries in the court record indicate sealed documents are closed proceedings. And she lists them all. She goes on for several pages, 2 pages actually, of citing all the hearings and all the orders that have been sealed. And then, like good legal writing, after outlining the facts, she states the law. She cites the United States Supreme Court, which has consistently recognized that the Constitution conveys a presumptive First Amendment right to access to judicial proceedings to the public and press, finding that a presumption of openness inheres in the very nature of the criminal trial under our system, citing the case of Richmond Newspapers versus Virginia, which is a 1980 decision. She also states that the United States Court of Appeals for the Ninth Circuit, which includes Idaho, also recognizes a constitutional right of access to court records, noting that the public and press have a First Amendment right to access to pretrial documents in general. And when considering whether a constitutional presumption of access applies to a particular proceeding or record, courts apply the logic and experience test, also called the press enterprise test. The test considers whether the place and process have historically been open to the press and general public, and whether public access plays a significant positive role in the functioning of the particular process in question. Ladies and gentlemen, I noticed this early on. I've been troubled by it. I've called out Idaho for this. I've called out Judge Boyce on this. I cannot think of a situation where you cannot go into just about any courthouse and sit down and plop yourself down. I don't care what the nature of the case is, whether it's a homicide case or an SAOC case, anything along those lines. You can sit in there and watch as a member of the public. And there's no way in hell that the court can kick anybody out. That is a violation of the defendant's right to an public trial, a public hearing. You can't kick people out. And when the courts start doing that, and if the defendant's objecting to this, the problem in this particular case for the defense is they've been going along with it. They're not objecting to it. They should be saying, I want all this information out there. I don't know why they're not saying, no, Judge, this is, my client has a right to a public trial. Let's put the information out there. Maybe something will change. Maybe something will change by this argument to basically say, Judge, you're violating the law. I continue. Ms. Hellis cites that in Idaho, access to civil and criminal court proceedings are broadly provided for in the state constitution. Courts of justice shall be open to every person, and a speedy remedy afforded for every injury of person, property, or character, and the rights of justice shall be administered without sale, denial, delay, or prejudice. Specifically cites the Idaho Constitution, Article 1, Section 18. In addition, Article 1, Section 13 of the Idaho Constitution specifically ensures that criminal trials are to remain open. Specifically, and I quote, in all criminal prosecutions, the party accused shall have the right to a speedy and public trial. Sounds just like, constitutional right, United States Constitution, right? Sixth Amendment, right? Exactly. To have the process of the court to compel the attendance of witnesses in his behalf and to appear and defend in person and with counsel. There are no Idaho cases interpreting the open court provision of Article 1, Section 18 of the Idaho Constitution, other than to say the Idaho State Code, Section 19-811, which allows a criminal defendant to request that his preliminary hearing be closed. is not unconstitutional under Article 1, Section 18, so long as the magistrate court issuing such closure order complies with the requirements of press enterprise, which we talked about a moment ago. Instead, the few cases that address access to court proceedings rely on the rights of a criminal defendant to a public trial under the Sixth Amendment to the United States Constitution, or to the qualified right of the media and public to access to court proceedings under the First Amendment. Although Idaho courts have not explicitly recognized a constitutional right of access to court records, the Idaho Court Administrative Rules 32, promulgated by the Idaho Supreme Court and grounded in First Amendment principles, provides broad access rights and procedural protections for the public. The public has a right to examine and copy the Judicial Department's declaration of law and public policy, and to examine and copy the records of all proceedings open to the public. And then there's an Idaho Code, Section 74-101, which memorializes Idaho's Public Records Act, and nothing in the act or its exemptions entitles the court to seal and thereby deny the public access to the court records. And under Rule 32, it specifically states that physical and electronic records may be disclosed or temporarily or permanently sealed or redacted by order of the court on a case-by-case basis. And it says that any person or the court on its own motion may move to disclose, redact, seal, or unseal part of the record in any judicial proceedings. The court shall, which is mandatory, hold a hearing on the motion after the moving party gives notice of all the hearing to all parties to the judicial proceedings and any other interested party designated by the court. The court may order that the record immediately be redacted or sealed pending the hearing if the court finds that doing so may be necessary to prevent harm to any persons or persons. In ruling on whether specific records should be disclosed, redacted, or sealed by the court shall determine and make a finding of fact as to whether the interested privacy or public disclosure predominates. If the court redacts or seals records to protected predominating privacy interests, it must fashion the least restrictive exception from disclosure consistent with the privacy interest. And what are those privacy interests, you may ask, Scott? Well, let me tell you, because Ms. Hellis has gone to the trouble to do it for us. 1, that the documents or materials contain highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. It's a homicide case. I think everything is pretty much open to the public. That the documents or materials contain facts or statements that the court finds might be libelous. It's a criminal case. The parties pretty much have immunity from anything they say. Okay. C, the documents or material contain facts or statements, the dissemination or publication of which may compromise the financial security of or could be reasonably result in economic or financial loss or harm to a person having an interest in the documents or materials, or compromise security of personnel, records, or public property for property of or used by the Judicial Department. I don't think we have that in this case. Or the documents or materials contain facts or statements that might threaten or endanger the life or safety of an individual. I can't think about that. I mean, the people are in custody, for goodness sakes, right? That is necessary to temporarily seal or redact the documents or materials to prevent the right to a fair trial. The court can impose a gag order so the attorneys don't do it, but the public should have a right to know what is being filed, what are in these statements. If the government screwed up, as is alleged in various motions filed on behalf of Miss Lori Vallow, then the public should know. It goes directly to whether the prosecutors are competent or not. Are they following the law or not? And there's been nothing to say that just because there's public information about a trial that people can't receive a fair trial. Think about of all the cases where there's news and information out there about a case. But you know what? Only thing that matters is what is the legal and competent evidence that is presented at trial. That's the only thing that matters. Is it admissible in court? That's what the jury is going to make their decision upon, not what's in the news, not what's being talked about by anybody else. I think the jury can make that determination, and the court can do that as well. And then finally, the document contains personal data identifiers that should have been redacted pursuant to the Idaho Rules of Electronic Filing and the Rules of Civil Procedure. Okay, we don't need people's social security numbers. I get it. Private information, medical records. I get that. That's fair game. but everything else should be open to the public. I've been saying this from the beginning. I don't like the way they do this in Idaho, and frankly, I'm a little surprised that the Idaho press hasn't filed any of these motions, that a book author has to be the one to move this issue to the forefront for the court. Everyone else just kind of went along with it. I guess I complained about it, but I just kind of went along with it, I guess. But at least this hero did something. Now, the argument that Ms. Hellis makes is that the drafters of the rules intended the process to be onerous, and the purpose or the specific procedure outlined in the statute encourages the process to be used sparingly and with due consideration. So just because it's a high-profile case doesn't mean that it gets, the rules don't apply. Remember, these are the rules that everyone has to follow. And the argument continues, there is no indication that the court even considered the factors in the Rule 32 because the court did not conduct a hearing as required by statute. Neither did the court document his findings on the record and in writing as the rule requires. There is no proof that the court considered whether any exception to Rule 32 applied. In fact, there is no indication that the documents or materials contain highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. The documents may likely contain a fact or statement the defendant and or the lawyers for the state and defense may find embarrassing. No provision in this rule permits the court to consider that when deciding which records to seal. There is no indication the document or materials contain facts or statements that the court might find libelous. Likewise, there's no suggestion that the document or materials contain facts or statements, the dissemination of public which may compromise the financial security or could reasonably result in economic or financial loss or harm to a person having an interest in the documents and materials. And there's been no suggestion that the documents and materials contain facts or statements that might threaten or endanger life. This court has made a single finding that it is necessary to seal or redact documents or materials to prevent the right to a fair trial. The court has never expressly indicated how the defendant's right may be at risk and has never said in his decision to seal that the record is temporary. I love this argument. The public's First Amendment right to access public records regarding this case has clearly been violated. The court decided to seal documents without a hearing, without notifying interested parties, and without making written findings necessary to seal. Further, the court made no effort to avoid sealing by using a less restrictive method, such as redaction. This rule is clear, and even when documents contain personal data identifiers, the remedy is redaction pursuant to the Idaho Rules of Electronic Filing and Service, Rule 15, Idaho Rules of Civil Procedure 2.6, the Idaho Rules of Family Law Procedure 218, not wholesale sealing. The court's decision violates Idaho statutes and rules, including Title 74, Chapter 1 of the Public Records Act, as codified in the Idaho Statute 74-102, and the Court Administrative Rule 32. To date, the court has not published any public findings indicating whether privacy interest is being protected, how the privacy right predominates the public's right to disclosure, or what alternatives to wholesale sealings were considered. The court has not considered the free enterprise test, considered whether the place and process have historically been open to the press and general public. Public access always plays a significant role in ensuring that the defendants receive fair trials and competent representation. In fact, public access is at the very heart of the rule. The argument continues. Neither the court nor the litigants have provided evidence that actual damage or prejudice will occur if the sealed documents and proceedings are unsealed. This is a death penalty case. The court has previously pointed out that such cases are different and require higher care and scrutiny. Nowhere is that true in a case of sealed documents and proceedings. How can the public or the victims be assured that such a sensitive matter is being prosecuted appropriately and fairly without access to the proceedings and documents? Moreover, the higher the level of care requires that the court take the time to fashion a less restrictive way to balance the rights of the defendant and the rights of the public. And in summary, The legal presumption in both Idaho law and the United States Constitution is for the release of court records, with the court sparingly applying the exception to the rule. The court to date has been doing the reverse, sealing court records and waiting for someone to object. The court's actions to date violate the victims and the public's First Amendment's right. The wholesale sealing of court records does not comport with the law in Idaho, the court rules, or the Constitution of the United States of America. Lori A.G. Hellis, thank you. You should get a Hero of the Day award. I've complained about it, but I haven't done anything about it. I guess I'm not really sure if I qualify as press, but I guess we're going to have to get that sorted out so that if something like this happens again, or maybe we file a very similar motion so that we can do that as well. Because I've never seen a case that I can think of where there's been such restrictive access to documents in a case. And I've said it many, many times that I'm offended by it. And I don't like the way Idaho's been conducting the rules. But Miss Hellis, she went the extra mile and filed it. And, maybe that issue will be addressed at the hearing that the court set on August 16th. Or somehow maybe we'll be dealing with something else. But at least somebody is objecting now. I'm a little surprised the prosecution isn't doing it. I don't understand why they have a problem with the public record being disclosed out there. Usually you don't want something out there because it's going to be embarrassing to you. Frankly, there's, the victims in the case, obviously, unfortunately, have passed away. What is it to them? Basically, the prosecution doesn't want their law enforcement techniques shown to the public. Maybe explains why it took so long to charge this case. I don't know. Was there incompetence? Was it great police work? We don't know, because we haven't had access to any of the documents that would normally be turned over. So, Ms. Hellis, if there's any assistance that I can give to you, please do not hesitate to contact me. Ms. Hellis should get the Hero of the Day award if we had one here at Crime Talk. Maybe we should. Good on her. I complained about it and I did nothing. I apologize. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. All right, let's move on the docket. Lawyers for the father of Harmony Montgomery. Remember her, the 8-year-old New Hampshire girl that's been missing since 2019? Well, the attorneys filed 2 motions to suppress statements that their client allegedly made to police on 2 separate occasions. Now, Adam Montgomery was arrested back in January for felony second-degree assault arising from a 2019 incident against his daughter Harmony, who was last seen in Manchester, New Hampshire back in 2019 when she was 5 years old. Now, Adam Montgomery has also 1 misdemeanor charge of interference with custody and 2 misdemeanor charges of endangering the welfare of a child pertaining to Harmony. He also was indicted on 8 gun-related charges and is the suspect in a 2008 killing. Now, the district attorney there in New Hampshire said that none of Adam Montgomery's charges are related to the disappearance of Harmony Montgomery. And as we stated, she was last seen back in 2019. She was reported missing by the police on December 31st, 2021. And Investigators say they've narrowed down Harmony Montgomery's disappearance to the 2 weeks between November 28th and December 10th, when her family was evicted from their Manchester home. Now, the reward for finding Harmony or providing information that helps authorities find her is standing at $150,000, thanks to a personal donation from a New Hampshire resident. Authorities urge anyone that has information on the young girl's disappearance to call the tip line at 603-203-6060. Back to the motion to suppress. According to the court documents, Adam Montgomery told the police that he had, quote, nothing to say, and he also was not advised of his Miranda rights. He was later arrested on January 4th and taken to an interrogation room where he was read his Miranda rights, according to the motion. And then a few minutes into the questioning, he told the police he had nothing else to say, according to the motion suppressed. The defense attorney's filing claimed police continued to press Mr. Montgomery after he asserted his right to silence. Mr. Montgomery has also requested additional time to file motions based upon a motion to suppress, asking for an extension of the deadline as they're still waiting for some of the body cam video. Now, ladies and gentlemen, what have we mentioned here many, many times before? Okay, if you are being arrested, do the police have to read you your Miranda rights? Not if they're just arresting you. Only if you're in custody and they're interrogating you about what's the matter you're in custody for. Now, let me explain to you the simplest way that you stop a police interrogation. Frank, roll the clip.
You, get up. Yeah, you.
All right, lawyer.
Now, as soon as the defendant asserts lawyer, he's invoked his right to remain silent. The police interrogation must stop. And if the court finds that the defendant was in custody and has asserted his right to counsel, there can be no questioning. Any statements made thereafter that would be suppressed. And if the police were able to use that information to go find more evidence, it too could be suppressed as a fruit of the poisonous tree. You can't break the law. You can't violate someone's constitutional rights to get to a result, even if you think it is a just result. Okay? Not the case. So, don't get me wrong. This Mr. Montgomery seems like a scumbag, but he has constitutional rights, ladies and gentlemen. And if we let the government violate the rights of the scumbags, they'll be doing it to the good people soon enough. Trust me on this one. It'll happen. Now, in some follow-up news, Harmony's stepmother, Kayla Montgomery, had one count of welfare fraud dropped in court, and Kayla Montgomery was originally arrested and charged with welfare fraud back in January for allegedly obtaining more than $1,500 in food stamp benefits. She allegedly didn't remove Harmony from the family's account with the New Hampshire Department of Health and Human Services, which amounts to the fraud. A judge dropped the charge on July 27th because the deadline for a grand jury indictment had passed, and Kayla Montgomery still faces several other charges, including 2 counts of receiving stolen firearms. And New Hampshire officials have said there is no connection between Kayla Montgomery's charges and Harmony's disappearance. No, but they're trying to sweat her. All right, news from New York. Now, some people said the other day in the comments that, my gosh, Scott, you don't like New York. I love New York, okay? I love New York. And before the pandemic, I'd been there a couple of times within the last couple of years. I love New York. But it looks like a scary place these days. You know, I don't, just being honest with you, all right? And it's guys like this. Now meet Michael Morgan. Well, he's facing charges of attempted murder and criminal possession of a weapon following a little incident that took place Monday at a fast food restaurant. And well, guess what? Well, he's also been charged with murder and criminal possession of a weapon in relation to a homicide going back to October of 2020. Now, Morgan had previously been arrested several times, including charges for grand larceny in 2019 and assault and theft of services in 2018. He also has numerous sealed arrest cases, but we have to presume that those cases have been dismissed, hence the reason for the sealing. Well, Morgan is also alleged to have killed 28-year-old Kevin Holloman after He was shot 3 times in the Bedford neighborhood in Brooklyn. Now, Holloman was shot in the front of his apartment building on Heckmeyer Street near Rochester Avenue, and he suffered multiple gunshot wounds, according to the police. For a while, the police tried to make an arrest and get this guy off the street. The guy should be behind bars, according to the police. Now, his mother, Lisa Fulmore, said she did not know why her son had a gun on him. This is referring to the McDonald shooting, okay? Now, Miss Fulmer claims that her son was acting in self-defense, and the McDonald's employee on the incident on Monday was still on the clock when he left the restaurant and went looking for her son regarding this little spat. Now, the tragic events unfolded around 7 p.m. on Monday, shortly after Fulmer and the employee got into a heated argument when she returned to the fast food restaurant to complain about her fries being cold. That's right. More food violence, ladies and gentlemen. It must stop. What is the basis for this food violence? Bad food. If we didn't have bad food, we wouldn't have crime, ladies and gentlemen. You get the logic, right? Anyway, well, Miss Fulmore said that she was on FaceTime with her son, who soon showed up at the store and stormed inside to defend his mother, despite her pleas to stay away because she didn't want him to get in any trouble. Morgan and one of the other employees, Mr. Webb, got into a dispute of their own inside the restaurant. At some point, it spilled outside, resulting in Mr. Morgan allegedly shooting the victim in the neck. So let's face it, ladies and gentlemen, who doesn't love New York? New York is a great place to be. But when you got guys like this running around who are going to go out and shoot people, I don't care if it was something that turned into something else. It started over food. Okay? It's a crazy world out there, ladies and gentlemen. The whole world has lost their mind. And I'm giving you this perspective from me, little old criminal defense attorney. And I'm telling you, it's like I've never seen it before. Next on the docket, remember those former police officers in Breonna Taylor's case? Some of them are former police officers. Well, guess what? The FBI has charged 4 current and former Louisville police officers regarding the deadly raid of Breonna Taylor's apartment back in 2020. Now, the ex-detective, I should say, Joshua Janes and Brett Hankson are all facing federal civil rights charges for their actions in the Taylor investigation. Now, the current Louisville Police Department Sergeant Kyle Meany and Detective Kelly Hannah Goodlett are facing the same charges. Now, Janes was fired by the Louisville Metro Police back in January of 2021 for adding a false statement to his sworn affidavit for the no-knock warrant to search Taylor's apartment over her drug dealer ex-boyfriend. As a result, Taylor was fatally shot by the Louisville officers on 13 March of 2020, sparking widespread protests around the country, as you may recall. Well, Attorney General Merrick Garland and Assistant Attorney General Kristen Clark announced the charges, including violations of Taylor's civil rights, unlawful conspiracies, unconstitutional use of force, and obstruction offenses. Now, the government alleges that the officers and their investigation unit falsified the affidavit used to obtain the search warrant for Taylor's home, which then led to her death. The Attorney General, Mr. Garland, also confirmed that Hankson, who was cleared of criminal charges earlier this year, has been charged with 2 counts of deprivation of rights under a color of law. Until now, Hankson was the only officer to be charged in relation to Taylor's death after firing shots through her window and a sliding glass door. He was found not guilty of 3 counts of wanton endangerment for firing shots into the neighbors' apartments. Taylor's boyfriend, Kenneth Walker, returned fire with a shot that struck an officer in the leg. Police then opened fire, hitting Taylor 6 times and killing her during the entire incident. As noted, Mr. Hankson was found not guilty of 3 counts of wanton endangerment, firing shots into the highly charged court case back in March of this year, and the Department of Justice confirmed that he will now face further charges for reportedly using unconstitutionally excessive force while acting in his official capacity. A separate indictment filed today claimed that after Taylor was shot, Hankinson moved from the doorway to the side of her apartment and fired 10 more shots. These shots allegedly went through a window and a sliding glass door, both covered with blinds and curtains, depriving 3 of Taylor's neighbors of their constitutional rights. The first count charges him with depriving Taylor and her boyfriend by firing shots through a bedroom window covered with blinds and a blackout curtain. Both counts allege that Hankson used a dangerous weapon and that his conduct involved an attempt to kill. Now, Mr. Janes, the lead investigator in the case, is accused of falsifying information on an affidavit used to approve the warrant to raid Taylor's arrest. He claimed that he had verified through a U.S. postal inspector that Taylor's ex-boyfriend, Jamarcus Glover, a suspected drug trafficker, had been getting packages delivered to her apartment. But he had actually spoken to a fellow officer, Sergeant Jonathan Mattingly, who had received the information from the Shively police. Now, Mattingly later resigned from the force and has not been charged in connection with Taylor's death. Officers Myle Cosgrove and Brett Hankson were also fired from their roles in the police over the Taylor case, and the Kentucky Attorney General Daniel Cameron failed to charge Mattingly and Cosgrove with a crime last year, saying that both cops were justified in returning fire against Walker. Now, both Cosgrove and Hankson were fired from the Louisville Metro Police Department for their actions during the raid. Merrick Garland said the federal charges alleged that the officers falsified information on that warrant used to enter Taylor's home. That's the gist of it. He said that this violated her Fourth Amendment rights, which resulted in her death, with Janes and Goulette knowingly falsifying a document created after her death. The charge claimed that the pair had allegedly met in a garage in May of 2020 to discuss telling investigators a false story to cover up their unlawful conduct. Sergeant Carl Meany reportedly lied to the FBI during its investigation of Taylor's death and has also been charged. Affidavits sworn by Janes and approved by Meany were used to obtain warrants to search 5 properties, including Taylor's home. The indictments claim that Janes and Meany knew that the affidavits to obtain the warrant was false, misleading, and out of date, aka stale. The affidavit also states that both officers knew that the warrant would be carried out by armed Louisville officers, creating a dangerous situation for officers and anyone at Taylor's homes. Janes and Meany have been charged with 1 count of deprivation of rights of color under the law and 1 count of conspiracy. Meany has been charged with making a false statement to the FBI, while Janes is accused of falsifying records in a federal investigation. Goulette has been charged with conspiracy with Janes to falsify the search warrant and covering up their actions afterwards. Attorney General Merrick Garland said Breonna Taylor should be alive today. The Justice Department is committed to defending and protecting the civil rights of every person in this country. That's a mouthful. So what does this really mean? Well, they lied. And it became very clear early on that they lied. And obviously that's why the case against the boyfriend fell apart. It was because everybody knew that they were not going to be there for a lawful purpose. Now, do you think this is the first time this has ever happened, that an officer lied on an affidavit to obtain probable cause, submitting a false affidavit to a judge because they want to take a little bit of a shortcut? Oh, it happens all the time, ladies and gentlemen. But nobody calls anybody out on it unless they go to court or somebody dies, like in the case of Breonna Taylor. We love police officers, okay? We love good police officers. Hell, we even like average police officers, but we don't like bad police officers. And a lot of the stuff will give these cops the presumption of innocence, okay? Obviously, one has been found not guilty, even though he shot his weapon 10 times into a crowded home that wasn't even being raided. That's just bad policing, bad police work, falsifying information, bad police work. These cops, bad cops, got to go. Let's keep the good ones, okay? Let's protect the good ones. But you got to do it right. And part of being a good cop is protecting everyone's constitutional rights. You don't get to take shortcuts just because you think it's going to justify the result that you want. Next on the docket, a case that I'm quickly thinking just needs to go away, okay? The mother of Gabby Petitio said Brian Laundrie lied about why he killed her daughter in a notebook confession found on his remains. Now, she went on national TV, this is Nicole Schmidt, her mother, and called Laundrie's purported confession that he killed Petitio as an act of mercy after grievously injuring herself an absolute lie. "That's ridiculous," she stated. "We know how she died," calling Laundrie's claims completely 100% untrue. She said the confession story he wrote in his notebook was merely a part of a good guy character he always masqueraded as. This was his character. Even in his last moments, he wanted to make sure he looked like the good guy. Now, Ms. Schmidt previously shared an image on Twitter that said, "Narcissists rewrite history," along with the hashtag including "The truth will be revealed, selfish, and justice for Gabby." Petitio's remains, as you may recall, were found in Grand Teton National Park back in September of last year after she vanished in August while on a vlogging road trip with Laundrie. Investigators determined she died by manual strangulation and had been dead 3 to 4 weeks. Her death was ruled a homicide, and after a national manhunt, Laundrie's skeletal remains were found in October on a nature reserve near Florida, near his parents' house in Northport. He died from a self-inflicted gunshot wound. I give Gabby Petitio's mother, I couldn't imagine losing a child, okay? Particularly to being a victim. I understand that. But everybody knows that he lied, okay? It's no secret that he killed her. The autopsy determined manual strangulation. There was no injury from some fall that she had received, putting her out of her mercy. Everybody knows that's a lie. I feel for her. But this is one of those stories where it's a tragedy. Laundrie's dead. I think we need to let it go. I think it's going to be the last time we talk about Gabby Petitio and Brian Laundrie. Unless, of course, there's something really good, then we'll talk about it. But I'm going to try not to. All right? Next on the docket, when life can be stranger than fiction, a 12-year-old girl escaped from her kidnapper who tied her to a bedpost and drugged her with alcohol by chewing through her restraints. Her escape led police to find 2 decomposing bodies in the home. Now, Jose Paulino Pascal Reyes, he's 37. He's been charged with first-degree kidnapping, 2 counts of capital murder, and 2 counts of abuse of a corpse in Dadeville, Alabama. The girl, who is not identified by police for obvious reasons, she's a juvenile, was found by a motorist around 8:30 a.m. on Monday when she was walking down County Road 34. After picking up the child, the driver immediately called 911, according to the Alabama police. She was reportedly assaulted, drugged with alcohol, and tied to a bedpost during her week-long captivity, and only managed to escape by chewing through her restraints, damaging her braces. Authorities did not indicate whether the pair knew each other or how she was taken. However, they did report that she was safe now and had received medical attention. Crazy, ladies and gentlemen. It just shows you evil exists in the world. Obviously, we'll give the defendant, Mr. Jose Paulino Pascal Reyes, the presumption of innocence, but it just shows you evil does in fact exist in the world, ladies and gentlemen. Evil exists. Next on the docket, our dumb criminal of the day. After throwing an urn, that's right, an urn, where you put the family ashes? Yeah. An urn containing a family member's ashes at someone. A naked man was arrested early Saturday morning. According to the Sebastian Police Department, Scott Cornwell got into a heated argument with the victim, which escalated when Mr. Cornwell threw a glass-styled urn at the head of the victim. As officers arrived on the scene, they found the victim at the neighbor's house. Their face had multiple swollen, bloody masses bursting open. That's for cuts, probably from being hit with an urn. The victim was transported to the hospital, where it was later discovered that they had a fractured nasal cavity, which usually means felony because you have a break or fracture of a bone or cartilage, and that's usually a felony. So police say they attempted to call Mr. Cornwell multiple times over the phone and knocking on the window, but there was apparently no response. But the police said after an hour, Mr. Cornwell left his home completely nude and was taken into custody by police. Mr. Cornwell has been charged with aggravated battery because you have a deadly weapon, the urn, and then you also have, the broken nose. That's a felony, ladies and gentlemen. Mr. Cornwell, that's dumb, okay? And next time you're going to have a little standoff with the police, put some clothes on, for God's sakes. That's just dumb. Nobody wants to see you naked. Jeez, that's just gross. All right. Let's go ahead and close the docket for today. Thanks for watching. We'll see you next time on Crime Talk.